Plaintiff has selected 4 true and correct videos representative of defendant's defamatory comments and mean-spirited attacks taken from Rekieta Law LLC show.
Yeah, we just found out why Rekieta Law is being sued, and oh man, this stuff is spicy. On top of that, the defense, they're pulling crazy moves. They're avoiding Rekieta Law so they can try to get a default judgment. Yeah, we'll talk about all of this. I mean, this is some crazy times. Hey there, by the way, let's get this thing started.
I'll pull up the things that they've cited for defamation. Okay, here we go. Plaintiff has selected 4 true and correct videos representative of defendant's defamatory comments and mean-spirited attacks taken from Rekieta Law LLC show, which is not a Rekieta Law LLC show. It's actually a Rekieta Media LLC show. So thank you. Rekieta Law doesn't have anything to do with
motion to dismiss.
That will be filed, I'm guessing. Rekieta Law LLC show, and uploaded them on on the Minnesota Digital Exhibit System. In these videos, defendant is heard stating plaintiff, quote, does not have a good name. That plaintiff made a, quote, snuff film about a kid, which he
yes,
did.
He did.
That plaintiff is a, quote, fucking it. Also true. That plaintiff has, quote, always been into sucking little boys. That's my reasonable belief based on the stuff you made.
According to information and belief.
Now, as far as the first and second allegation, they discuss a little bit more of that. Plus, they discuss how much money is being asked for. They discuss what they think about the filing here. Let's listen to that as well.
That's the big problem.
Monograph, yeah.
He literally does have a bad name. He made a video that they wouldn't release because it was so wildly offensive and horrifying, and it's effectively a snuff film about a little boy. That's why they wouldn't release it. It's like the 3rd movie or whatever that he made.
Now, Nick, I have a question for you, because some of this, the way this motion, like parts of it that I've seen, sound like Monty completely. It sounds like he gave it to these guys and said, "File this."
Yeah,
but like that's. You know, I don't know about Minnesota, but there's no way in fuck I would do that here. Like, if somebody gave me some, hey bro, file this, I'm like, no, I'm reading it. Like, if my name's attached to it, like you can't just do that.
I don't know what the arrangement was based on the complaint. My guess is that they said they would just my assumption and guess is that they said they would file. Or they would serve and file a complaint and hope for default. And that if this thing went beyond like default or an initial negotiation, they would want to renegotiate like their agreement. Because I can't imagine they're taking this on contingency.
No.
Because the requested amount is only $50,000 anyway. So their contingency is only going to be $15,000.
Sure. But I'm just saying, though, did they actually read through this fucking thing? And then they still wanted to go ahead on it. I'm like, that alone, that's a dangerous thing to do as an attorney. You just
based on his, I mean, he wrote this affidavit, and so based on the affidavit, all I can think is, I mean, he's attaching his not monograph, but the attorney's attaching his name to it.
Now, on top of that, Rekieta Law talks about his lawyering situation, discussing filing pro se, and while he's doing this happens over 2 streams. Props to Alyssa Clips for all of this compilation.
Binger finger, I'm not technically represented yet. My lawyer has not made an appearance or anything. I actually filed my motion today pro se. So I'm not represented. There's never been any indication that I'm represented. So they kind of have to talk to me. And by the way, if I was represented, they would talk to my lawyer, which they haven't done either. They're intentionally not answering my calls or emails, which is not what you want to do, for the record. So just the retainer has been sorted so far. That is, I indicated my intention to send a retainer. By the way, I did not do it when I indicated. So as far as the world is concerned, I am completely unrepresented. My lawyer has not made an appearance before the court. It's just me, pro se. Haven't you hired someone now? Why are you still writing up your own documents? Because the person I hired is not... One, they haven't appeared in court yet. 2, or appeared before the court. 2, they don't do Minnesota procedural issues. So I'm taking care of the procedural issue first, which is the default. So if I have to hire a Minnesota procedure person for it, I will.
Now, as far as the case is concerned, the guy suing Rekieta Law, Monographed, has moved for a default judgment. And the way that they got to this, well, let's hear Rekieta Law explain it. And he's going to give you his theory on why exactly this is taking shape.
I've never seen an attorney literally ignore communications with an adverse party and then admit to ignoring them in their affidavit and then move for default judgment. Like here, I'll read that in just a second. Here we go. Upon information and belief, defendant called your affiant's office and left a voice message on December 30th requesting an extension of time to file the answer to answer the complaint until January 31st. On or about this date, it was on the date, literally 6 minutes later, which I told him in the voicemail that I would be composing an email to memorialize the communication. Defendant also sent your affiant an email making the same request. In neither communication did defendant deny or essentially answer the complaint. Your affiant did not respond or offer defendant an extension of time to answer. Like, you didn't answer. Like, you didn't respond to a communication with an adverse party, and then you're going to go to the court and say that the other party isn't making any sort of effort.
Now, since Rekieta Law is pro se or representing himself at this time, he notes what this actually means with regard to Monographt's attorney.
Ignoring me is akin to ignoring my ignoring counsel, trying to confer on a pending matter. Very dumb. Like, again, you just don't do this. You don't do that, but whatever. Then I had to file my fucking motion today for this extension of time, which shouldn't have to happen. It shouldn't have to happen. You just ask the other party for an extension of time, and it's the first time, and they just say, yeah, of course you can have an extension of time. Why wouldn't we do this?
Now, Rekieta Law speculates on why this is happening, and I thought this was kind of interesting.
Right? The goal of Monographed appears to be to file a frivolous lawsuit, and the goal of his attorneys was probably the point was to probably try and get a default judgment, because if this goes to trial, they probably don't think Monty can afford it. And so they'll try and win on this this sort of legal procedural technicality. But the problem for them is I'm not avoiding them. I'm not delaying, like I'm not trying to cause unnecessary delay. I asked for a 1 month extension, which is nothing. Like, it's completely nothing. So we'll see.
There's going to be a lot more to this too, but let me know what you think so far. And as always, appreciate the heck out of you. You make this stuff work. Thank you. Can't say that enough. Want to help out the channel? Links are in the description. Check those out for sure. We could always use your help. But more than that, thank you. Appreciate you sincerely. Share this everywhere. Thanks.